Who are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. See, this is what happens when I take time off. So I took off Thursday afternoon and Friday to drive up to Fresno. A friend of mine was having her big annual Halloween party. It's always a big bash, and so I go up there and help her out, and I didn't come back until yesterday evening, and trying to refocus back onto work. So anyway, so this is Trust and Estates Weekly. It's Monday. It's 10 a.m. Pacific time. And we're going to talk about serious stuff here now. Serious stuff. Okay. I actually got to start out my day by having a creditor chastise me for not having sent her or not having recognized her claim, and I sent her a copy of the appropriate form, which we'll talk about in a moment, and essentially wished her well. So, the moral of the story is, don't go on vacation, even for a day and a half. Don't go on vacation. So, okay, well, so today I'm going to be talking about when an estate owes money, which is almost all the time. Very few people pass away not owing a penny. Now, I have talked before about priority of creditors' claims, but I don't think I've talked about the process that one has to go through in order to have that claim recognized. I should say the process that one has to go through to ensure that one's claim is recognized, because while some claims are recognized automatically, okay, other claims have to be recognized by the court. So if you recall, if you happen to see the episode on priority of creditors' claims, so if, first of all, the claim for the personal representative, me, right? Okay, I don't have to file what's known as a creditor's claim. By virtue of having been given letters of administration, it's understood by the court, and it's part of the process, that prior to the probate closing, I'm going to file a claim for fees, and that indeed the priority for that claim to be paid is first in line. And there's a good reason for that, because if I administrated an estate and other creditors came ahead of me, I could end up having done a lot of work and never getting paid. Because once the assets of the estate are gone, there's no one else who has the obligation to pay a personal representative, an administrator, an executor, etc. Right? And so that's why it's set up that way. By the way, the lawyer who represents me also has a number one priority claim for the same reason. So I at this party, a number of people, what do you do? Oh, and so I tell them, you say, oh, you're a lawyer. I said, no, I'm not a lawyer. Nothing wrong with lawyers, but I'm not a lawyer. I do, however, have a lawyer who represents me. The lawyer handles the legal side of things. I handle the administration side of things. That's how the tasks are broken down, basically. And so, again, if the lawyer's claim were not paid number one priority, no lawyer would agree to represent me, and that would hamper, if not completely impede, the administration of the estate. Okay, so secured claims. So if somebody dies and there's still a mortgage on their house or a loan on their house, so the mortgage holder does not have to file a creditor's claim. That's a secured claim, and it will be dealt with as part of the administration of the estate. But if you have an unsecured claim, okay, so let's say that you paid for some of the funeral expenses. Or let's say you had lent the decedent some money. Maybe you have a note. Okay, so you actually the decedent before he died signed a note. That's evidence of your claim. Good. Okay. Uh, but that claim is, but let's say there was no collateral for the debt. So it's not a note secured by some kind of lien on the decedent's house or some other property he has. It's not a car loan, for example. Those are probably the two most common debts estates deal with are home loans and car loans. Okay, so an unsecured debt has to file a creditor's claim. Okay, so I gave you two of the most common. One is somebody essentially advances money to pay funeral expenses. And another is someone has some other type of unsecured debt. They lent somebody some money and, there was no collateral for it. It might have been a loan between friends or business associates. And so there's a high degree of trust there. And then that's why they didn't require collateral. But in the end, the person died. And so now the creditor's claim has to be sustained by the court in order for it to be valid, or not really the court per se, but it has to be sustained as part of the administration process. Okay, so that's what we're talking about here. I know, for my situation, I have a couple of loans out to friends right now who helped me during some difficult personal things that have happened in the last that happened in my life over the last few years, and I made sure they all had notes, written notes that I signed, for the debts, because if as we say, God forbid, I did die before they were paid back. I wanted to make sure they had evidence that my estate, owed them the money, and that way it would be as easy as possible for them to get their claim paid. Okay, so I'm going to be going through the process here in California. The process is not identical in all 50 states. Not to mention the various territories, Guam and Puerto Rico, etc. But it will be similar, to this process. And so if you're in, Alabama, or you're in Ohio, or you're in Idaho, it's, I would say, go on ChatGPT or Perplexity or Claude, one of the large language models, and just query, what is the process for filing a creditor's claim in probate in whatever state that you're in? It's going to give you pretty cogent advice. Okay. So, just to give you an idea, I used ChatGPT to prepare my notes for this particular episode, and it gave me, let's see, 8 steps, I think. Okay, it gave me 9 steps. Step 9 is special situation. It gave me an 8-step process for filing a creditor's claim here in California, and then I reviewed it because you have to. Okay, and it's absolutely correct. Okay, so these LLMs are getting much better. If you're brand new to doing something like this, so you may not be able to double check it, but as long as the correct form is identified, okay, and you fill out the form and file it with the court. Okay, so the good thing about the court is if a form is filed incorrectly, they'll either reject it for filing, at which case you can ask the clerk, what did I do wrong? And they'll generally help you fix it. It's not their job to give you legal advice, but if it's something you filled out wrong on the form, that they usually will help you. Or they will refer you to kind of a section of the court that helps lay people with filling out forms that need to be filed. So I know here in Los Angeles in Superior Court, there is an office in the Superior Court where the people there, their whole job is to help non-lawyers fill out forms properly so that they can be filed with the court. Okay, so that's, so, but having this background will help you understand the overall process. And then when if you do need to go file a creditor's claim and fill out that form or whatever, you'll be able to do so more easily. Okay, so step number one is to determine whether you have a valid claim to begin with. So a creditor is anyone owed money or property by the decedent at the time of death. Okay, now notice it's at the time of death, meaning that the debt was incurred prior to the decedent dying. Now, contrast this with an heir. Okay, an heir is not a creditor. Okay, they were not entitled to any of that money prior to the decedent dying. What they're entitled to after the decedent dies is whatever share of the estate has been given to them under a will, or to which they're entitled by the laws of intestate distribution in the particular state in which the probate is occurring. Now, in some cases, an heir can be a creditor too. Okay, so let's say an heir. Let's just take an example of a sister of the decedent. Let's say she paid the funeral expenses. Okay, so she's entitled to be reimbursed for those expenses. Okay, but those expenses actually make her a creditor to the estate. Now you say, wait, I thought you just said it was money or property owed by the decedent at the time of death. Yes, however, there was no way to anticipate, prior to the decedent's death, that funeral expenses were going to need to be paid. And so funeral expenses actually are a higher priority claim than an actual unsecured debt. They nonetheless, they are processed as, generally speaking, they are processed as a creditor's claim, especially in an estate where there are disputes between the various heirs as to whom money is due, or there's disputes about who is a legal heir, et cetera, et cetera. In such cases, okay, an administrator would be insane to just go ahead and reimburse expenses without it going through the creditor claims process. Because if one of the other heirs disputes that claim, now the administrator could become personally liable for money that was paid in reimbursement. Okay, so you can see that the creditor's claim process is there to protect the heirs first, or the estate really, and by extension the heirs. Okay, but there is some discretion on the part of the administrator. Okay, as an administrator, an executor, personal representative, whatever we're going to call them, they are not required to take a step that might put them in legal, or shall we say fiduciary jeopardy. Even though they may have the authority to do something, exercising that authority may put them in a situation of liability. And so administrators always have the option of applying to the court for an instruction or for instructions. And in a situation like that, the proper way to do so may be the creditor's claim process, okay, because it's already set up. And indeed, what the person is asking for amounts to getting a debt repaid. Okay, so and I talked about different types of credit claims. Okay, so that's number one. So determine if you have a valid claim. Okay, now you may not be able to do that completely, and so you may decide to file a claim. And if it gets denied, okay, it gets denied. It's not very. You'll see. I'm going to show you the form in a little while. You'll see. It's not going to take you very long to fill out the form. So it may be if you think you have a valid claim, even though it may seem a little bit debatable, under the law, in this case, in California probate code sections 9900, no, I'm sorry, not 900, 9000 through 9003. Okay, so frankly, while normally I would say, talk to an attorney about this, you may say, well, but the claim's for $400. I'm going to spend $300 talking to an attorney to try and, collect $400. It doesn't make sense. Yeah, I get it. At that point, you may just decide, this is not me giving you advice. As you know, I don't give legal advice, but it may just be, more economic to go ahead and file a claim. And let the administrator, figure it out. And if it has to go through the court process, it'll go through the court process, and you can show up at the hearing. You'll be notified. You don't necessarily, and if on such a small claim, if you show up without a lawyer, the parties are going to understand. Or anyway, the judge and the administrator is going to understand. By the way, if an administrator were to admonish you why you're here without a lawyer when you're seeking a few $100s, I don't know what to tell you. That's just not a particularly smart administrator. It's obvious why you're there unrepresented, and certainly the judge is going to understand that. If you think the judge doesn't, just say, Your Honor, the claim is only for $400. I mean, I can't afford to spend, that or more trying to collect the debt. I might as well just have, left it uncollectible, but it's a valid debt. And so, I filled out the paperwork as best I can, and I'm here this morning to answer your questions. And again, most people involved in the probate process, they're going to understand the situation in which you find yourself, and they're going to seek to do whatever is the correct thing under the law, and that's going to be that. Okay, so all right, so determine whether you have a valid claim. Number two, identify the proper time frame for filing. Okay, so it is not an open-ended process. Okay, so creditors' claims in California need to be filed within 4 months after letters of testamentary, or what are called letters of administration, are first issued to the personal representative. Okay, so if let's say letters were issued today, November 3rd, 2025. So you would have until December, January, February, March. You would have until March 3rd, 2026 to file a claim. Okay, so 4 months. Or 60 days after the creditor receives a notice under probate code section 9050. Okay, so if a creditor sometimes, a creditor it doesn't know that the person has died. Okay, and so 6 months into the administration, they find out, oh my gosh, my debtor has died. Okay, okay, so then they contact the administrator, notify him that hey, the decedent owes money to them. Okay, and then the creditor will give them notice. Okay, a proper legal notice. Now, in that case, they only have 60 days to file their claim. Okay, not 4 months. Okay. And so, you need to keep those deadlines in mind, because if the deadline passes and you haven't filed the paperwork, then it's very likely that your claim will be barred. Okay. So I have an estate in Alabama that I'm administrating, and um, years, well, not, yeah, I think it was actually over a year and a half maybe after the decedent died, a credit card company, I believe it was American Express, filed a creditor's claim, and uh, the claim was not timely filed. Okay, and so my lawyer contacted American Express and said, "Hey, your claim wasn't timely filed." And American Express said, "We don't care. We're going to fight it." Okay. I mean, there's no money left in the estate, so good luck. Good luck with that. My lawyer is pretty confident the court is going to dismiss the claim because it was not timely filed. Okay, so that's not at all unusual. Okay, so uh, so next is identify the proper time frame for filing. Number three, request a notice of administration. Okay, so the personal representative, the administrator, has to send a written notice of administration to known or reasonably known creditors. That's the those are the notices that I mentioned before when talking about the time frames. Okay, and the notice also informs the creditor where to file their claim. Okay, so here in California, there is essentially a probate court in each county, right? So here in LA County, we have actually more than one courthouse. Okay, so there's a courthouse in downtown. There's another one in the San Fernando Valley. So, but probate cases are heard only in the downtown court. Okay, so if someone files a creditor's claim at the San Fernando Valley court of the Los Angeles Superior Court, County of Los Angeles, that's not going to work. They have to file it in what's called the Stanley Mosque Court, which is the downtown court of the LA Superior Court. Okay, so that notice will specify in which court the creditor's claim has to be filed. Okay, so that's step number three. Let's take a break, and we'll come back and talk some more. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. Okay, so this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. We're talking about when the estate owes money, what's known here in California as the creditor claims process. Talked about determining whether you have a valid claim, identifying the proper time frame, that requesting and receiving a notice of administration. Okay, and so the next step number 4, is completing the creditor's claim form. So I'm going to go ahead and share my screen here. And I think this is it. Yep. And there it is. Okay. So here, let's make this larger so you can see it. No, it doesn't want to do it. Okay. Well, I think that's as, oh, here it is. Here's the button I'm looking for. Oh, okay, it doesn't enlarge. All right, so that's as large as it's going to get. Okay, so this is form DE 172, and you can see right here it says creditor's claim. In California, this is the form you use for filing a creditor's claim. And you can see that I'm not going to go through every section, but this top part is really the relevant part. So, attorney or party without an attorney. So you just put in your name and address. In other words, the court wants to know uh, where you can be contacted, telephone numbers and fax numbers if appropriate. Okay, and that's what goes here. Now, if it's an attorney filing it, then the attorney's client's name will go here, attorney for name. If you're filing it on your own behalf, so you just put your name there, you're not an attorney, so you'd leave that blank. Okay. Next, you have the address of the Superior Court of California, County of, and in this example, Los Angeles. Okay. Street address, mailing address. Okay. City and zip code and branch name. Like I mentioned, Stanley Mosque. Okay. And then estate of. So, what is the name of the estate? Okay. That's the probate cases go by the name of estate of, and then the decedent's full name. Okay, so La Havdil, as we say, the estate of Kevin S. Bemmel, and here it says decedent. But it's also going to have a case number assigned to it, and that case number is in some ways more important than the case name, okay, because the case number will always be unique. Okay, now up here you see it says for court use only. When you file this document with the court, it's going to be stamped here. It's going to be a time stamp showing the date and time of filing, where it was filed, etc. And once you have the document with the filing stamp on it, these days it's done electronically, of course, but once you have the filing information in this area, now you know that the court has at least nominally accepted your claim. Okay, that doesn't mean the claim will be sustained. It just means that the court is, and now it's going to get reviewed by the appropriate parties. Okay, so, and then here you just got 6 questions to answer here. Total amount of the claim, that's how much you're owed. Claimant, the name, okay, the claimant may be you, it may be a company, and you can see it's an individual or or entity doing business under a fictitious name. Okay, it could be a partnership, a corporation, could be an LLC, that would go under other. Okay, so that's number 2. Number 3, address of claimant. Same, the address. Number 4, claimant is the creditor or a person acting on behalf of the creditor. Now, if it's a person acting on behalf of the creditor, you need to state the reason why. So let's say your parent is the actual creditor, but your parent is not able to take care of this kind of business, and so you are acting under a power of attorney to handle the business affairs of your parent. Okay, so in this case, you're filing it, on behalf of such and such as their attorney in fact, and you would just specify that there. Okay. And then claimant is the personal representative or the attorney for the personal representative, if that's the case. Okay, and then number 6, I am authorized to make this claim, which is just and due or may become due. All payments on or offsets to the claim have been credited. Facts supporting this claim are either on reverse, meaning on the other side, not likely, or attached. That's why when I was talking about if someone owes money and they like having a copy of the note that evidences the claim is important. Okay, then you fill in the date, you type in your name, and you sign it, and you're done. You can see it's a very simple form. Now here you could put in the facts supporting it if you wanted to, but if you have no actual written evidence, you'll just put the facts here, and then you have to do the proof of mailing. Okay, which I'm not going to get into, but in any event, this is the creditor's claim document here in California. You can see it's pretty simple to to deal with, and especially if you have a small claim. That's why I recommend just do your best and go to the court, get their help. Okay. And that way you might be able to still sustain your claim without having to pay more in legal fees than the claim itself is worth. Obviously, if it's a larger claim, you're going to want to get, for sure, you're going to want to get legal advice. You don't want to make a mistake and then have, a multi-thousand-dollar or more claim, uh, denied by the estate or by the court because you've made some kind of error that wasn't, and it didn't get corrected in the proper amount of time. And now the deadline has passed and, too bad for you kind of thing. Okay. All right. So complete the creditor's claim form. And you can see I just showed you the form itself, so you can see what needs to be done there. Okay, so that's step number 4. Step number 5, file the claim with the probate court. Okay, so you take the document. I mean, worst case scenario, you take the document to the court, you go to the clerk's office, you wait in line, and you file the document. Okay, and if you're filing it hard copy paper, the clerk may actually stamp it. Okay. These days, a lot of courts allow for documents to be filed online. Okay. So, maybe you have a lawyer friend who, as a favor, will file it online for you. And that way it will save you the trouble of having to drive to the court. Okay. If not, there are what are called attorney services, and these services, for a fee, will file a document. They're not particularly expensive. And so, if it's, like if you live in Los Angeles and it's in a couple of hours to drive to the court and back, you may decide it's more economical to, pay to have the document filed than it is for you to drive all the way downtown through the traffic and whatever, and then wait in the line at the clerk's office and all of that. Okay. Candidly, I avoid filing things in person, if I possibly can, because then there's also parking. You got to pay for parking because there's no place to park for free in downtown Los Angeles. But if you live in a small county where the court is not, overwhelmed and very busy, so it may not be a big deal. A 10-minute drive, 15-minute drive to the court, and you walk in there. I know when I had to file a document in Bessemer County court in Alabama on a matter I was handling there. My gosh, the clerks were just so friendly, so helpful. Even the security people going into the courthouse were just incredibly helpful and friendly. And then I'm doing the old, when you're in a new building, you haven't been in before, and you're trying to figure out where to go, and then someone saw me doing the look, came and said, "May I help you?" I said, "Yes, I'm looking for the clerk's office." And she said, "Oh, sure, yeah." She said, "Look, she will kind of walk me partway there." She says, "See that door there at the end of the hall where it's open? Just go right in there." Thank you so much. Right? Candidly, people are not that friendly at LA Superior Court, at least Stanley Mosque. So, but in any event, you need to file the form. Okay. And get that stamp on it, whether it's, an actual stamp or whether it's the electronic stamp, largely immaterial. But that's, again, what it, verifies that the claim has been filed. And of course, the date it was filed, that's the date that matters with respect to the deadline. Okay. So, if you're getting close to the deadline, you may choose to go to the court to file it yourself to make sure that nothing happens to, with the filing service you're using, and then it gets stamped too late because they filed it late and now your claim is denied because it wasn't timely. Okay. So all of those things, you want to consider. And, and in the end, even if it's a small claim, you may choose to use an attorney. Maybe the attorney will just take, 10 minutes to look over what you've done, verify it's correct, and go ahead and file it for you. And that way you can be assured that, that it was filed correctly on a timely basis. And okay, so you got to pay for 10 minutes of the lawyer's time. Even at $700 an hour, that's $70. Well, no, it's more than that. It's a sixth. So whatever it takes, it's a hundred and some odd dollars, $120 basically. And maybe that's good insurance to make sure that at least your claim is timely and properly filed. Okay. All right. So file the claim with the court. Number 6, deliver a copy to the personal representative, the administrator, the executor, etc. Okay, so within 30 days after filing, the creditor must serve a copy of the claim form, the claim with the filing stamp on it, to the estate's personal representative or attorney of record. That's the attorney of record is the attorney for the personal representative. Okay. So it can be mailed. And that's why you saw that proof of mailing there. You can also, I would recommend that if you are going to mail it, that you do so certified mail so you can track it, make sure it's been delivered, get a signature for delivery so that whoever receives it signs that it's been received. Okay. Because you've got another 30-day deadline there. Okay. So it's not enough just to file it with the court, but it has to be served on the administrator or the administrator's lawyer as well. Otherwise, in theory, how would they know about it? Now, of course, a good administrator is checking the court record periodically. I know I check the court record virtually every day that the court is open. Okay. Full disclosure, didn't check it on Friday, was on vacation. Okay. But, and, I mean, fortunately, nothing happened of consequence. And if it had, I have someone who backs me up on that kind of stuff. He would have let me know. He would have called me and, rallied the troops, so to speak. But in general, even if the administrator like me regularly checks the court records, it doesn't matter. You're still required to serve a copy on the lawyer. Okay, let's take another quick break and we'll come back and wrap this up. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. So, and just a sort of a little follow-on to that spot about Probate and Trust TV. I did a show on it a while back, but it seems like lately I've spoken to a number of people who are at least potentially interested in getting a professional fiduciary license and administrating trusts and probates here in California. So I would encourage you, if you're investigating that as a career, to check out Probate and Trust TV. There's a tremendous amount of great information there. I think I've got 9 or 10 content providers now, all of the top content providers on YouTube within the trusts and estates space. So you'll find, a variety of voices talking about what it's like to do what we do. And I think that will help you make a decision as to whether this is, the right professional path for you. And by the way, you can always feel free to contact me about that. I'm always happy to help people get involved in the profession of administrating trusts and estates. There is nowhere near enough people doing it, at least here in California. Okay, so we just talked about the next couple of steps: file the claim with the probate court, deliver a copy to the personal representative. Okay, now you have to wait for the claim either to be allowed or for it to be rejected. So just like you had to deliver a copy or serve a copy on the personal representative within 30 days of it being filed, now the personal representative has 30 days to allow or reject your claim. Okay. Now, it's a pretty simple process. And the rejection of the claim has to be done in writing. So it's not enough for the administrator to just say, no, this is a nonsense claim, I'm not going to pay this. I would hope, by the way, that no administrator would be so cavalier. But if for some reason the administrator rejects the claim, okay, he has to do so in writing, notifying the creditor. Okay. And the reason that's important is having timely filed the claim, even if it's rejected, that doesn't mean that you are forever barred from trying to collect that money. It just means you're going to have to go the next step. Okay. So if a claim is allowed, of course, okay, you're good. So the claim will be paid, but it's not going to be paid right away. It's only going to be paid as part of the distribution plan that the administrator submits to the court, okay, because of the fact that there are priorities of claims, okay? So your claim may be allowed, but because of prior claims, you may not get paid because there's insufficient money to pay you. Okay. Now, you will always have a claim superior to the claim of the heirs. Okay. Now, again, the heirs don't have a creditor's claim. I just mean the claim that the heirs have on the estate as heirs. Okay. Their claim is last. All the debtors of the estate, all the creditors of the estate will be paid first before money is distributed to the heirs. Okay. And that's why sometimes you will see that early on in the administration of an estate, if heirs kind of get the gist that this is going to be a creditor heavy estate, and that in fact the estate may be insolvent, okay, they will take advances on their inheritances, knowing that even though they may only get 50 cents on the dollar of what they might inherit from the estate, in the end they're likely to get nothing because creditor claims are going to eat up the entire value of the estate. And so at least they'll get half. And then who's the loser? Well, the loser is the company that advanced funds to the heirs. Okay. And I think I have is he coming up, or did I already? Trying to remember. I think I have a guest coming up to talk about this. Oh, no, I had a guest. Yeah, we talked about this. So my guest, Mark Harris, if you go back to the show that I did on October 6th, so Mark Harris and I talked about probate advances and how all that works. And Mark said, sometimes we lose our bet. Okay, that's how it goes. All right. So now that's an acceptance. If your claim is rejected, okay, that doesn't mean that's it, you're done. What it means is, okay, and by the way, maybe part of the claim is allowed and the rest is rejected. There's different ways, this can happen. But let's say at least part of your claim was rejected. Okay, now you have to file a lawsuit within 90 days after the notice of rejection, or your claim will be barred. So you can see that time is of the essence in all of this creditor claims process. What the court, I should say, what the state of California wants to avoid is a situation where the closing of a probate is held up because creditor claims are dribbling in. Nope. Get in, get your claims submitted, get them accepted or rejected. If they're rejected, get that lawsuit in. Otherwise, you're done. Okay, your claim is going to be barred. Now, what will happen in lawsuit? Just like what happens in any lawsuit. Okay, so you're as the petitioner, you will file your evidence that your claim is valid. The personal representative who rejected it will submit whatever evidence he has as to why he rejected the claim. and then the judge is going to make a decision. It's unlikely to be a jury trial. I've never heard of a jury trial in a creditor's claim situation. Okay, probate court is not a jury court, if you will. Okay, so it's going to be the judge's decision. Now, let's say that the judge sustains the decision of the personal representative in saying that the claim is rejected. That doesn't end it there either. Okay, you always have the ability to appeal the probate court judge's decision. Now you're starting to get into some very serious money. It can easily cost $25,000 to $50,000 just to file the appeal. So if it's a small claim at that point, you may just give up. But if it's a large claim, okay, I have one estate that I'm administrating where the claim against the decedent is almost $3 million. They spent years getting the claim sustained in probate court, okay? So in a case like that, even if the probate court judge had rejected it, in this case he didn't, but if he had, I imagine the claimant would have appealed that ruling because it was a large claim, number one, and number two, the claimant is a very large company. I won't say who they are. I don't want to cause that kind of stuff, but they easily could afford the cost of an appeal, and I imagine they would have filed an appeal. Okay, and I mean, I suppose even if the appellate court rejects the appeal, you could appeal it to the Supreme Court, especially if there's some sort of fundamental legal issue there that maybe you feel the probate court and the appellate court overlooked. So then maybe at that point you would appeal it to the Supreme Court. Again, it would have to be worth it, or you would have to be doing it on principle, which it's expensive to be principled in that respect here in California. Okay, all right. So that is the process for filing a creditor's claim. Okay, now there are some special circumstances that I'm not going to talk about today. I've talked about secured debts before. I talked a little bit about them at the beginning of this episode. So those are different. They don't have to go through the creditor's claim process. Now, you may have some kind of contingent debts, those kind of things. Once you're into those complexities, you need to get a lawyer to help you out with those. They're not straightforward cases. And at that point, you need competent legal counsel in order to see to it that your claim is handled properly. Okay, so what I've talked about today is just kind of the administrative side of creditors' claims, which is, again, not a lawyer, so not giving you legal advice, but this is the administration side of creditor claims here in California. And again, it's the process in other states is I suspect pretty similar. I haven't handled cases in all 50 states, but in the ones I have, it's like I said, it's pretty similar. There are deadlines for when a claim has to be filed. The claim has to be served on the personal representative. The personal representative has a certain amount of time to allow or reject the claim. The lawsuit following up a rejection has a certain amount of time to be filed, etc. Okay, so if you have any thoughts, questions, comments on this episode, all of my social media links will be in the show notes on YouTube after this episode posts. Feel free to use those avenues to communicate. If it's a legal question, I'll get back to you with an offer to refer you to a lawyer who is qualified to answer that question. I'm happy to do that. I know lawyers pretty much everywhere in the country now. And so I'd be happy to connect you with someone who can help you if you have a creditor's claim, really anywhere in the country. And for that matter, if you have a creditor's claim outside of the United States, I have someone I can look to get you a referral for a creditor's claim in wherever, Mexico, Canada, Europe, etc., Asia. Okay, we'll make sure you get somebody competent to help you with that. So, all right, I thank you very much for joining me today. And let's see, tomorrow, 10 a.m. Pacific time is my show, Business Lessons from the Military. And then on Wednesday at 10 a.m. Pacific time is my show, People Making Money. And this Thursday is my every other week show at 5 p.m. Pacific time, Jiggers' Place. We're going to have a cocktail and a schmooze. And that will then wrap up the week. So I hope to see you later this week. And in the meantime, once again, thank you so much for joining me, especially my live guests. And I wish you a wonderful rest of the day. And signing off as I always do, Marie, darling, you are my pal.